Ready, start. It is no doubt true that financial resources are needed for providing these facilities. Stop. But at the same time, it cannot be ignored that it is the constitutional obligation of the state to provide adequate medical services to the people. Stop. Whatever is necessary for this purpose has to be done. Stop. In the context of the constitutional obligation to provide free legal aid to a poor accused, this court has held that the state cannot avoid its constitutional obligation in that regard on account of financial constraints. Stop. The said observations would apply with equal, if not greater, force in the matter of discharge of constitutional obligation of the state has to be kept in view. Stop para. Relying upon the decision of this court in the case of Swaraj Abhiyan versus Union of India 2016 7 SCC 498 paras 120 to 123, it is submitted that as held by this court, a plea of financial inability cannot be an excuse for disregarding statutory duties. Stop. Reliance is also placed on the decisions of this court in the cases of Municipal Council Ratlam versus Vardichan 1984 SCC 162 and Khatri versus State of Bihar 1981 1 SCC 627, and it is submitted that as observed the state may have its financial constraint and its priorities in expenditure. The law does not permit any government to deprive its citizens of constitutional rights on a plea of poverty. Stop. It is submitted therefore that plea taken by the central government that the prayer of the petitioner for payment of ex gratia compensation for loss of life due to COVID-19 pandemic to the aggrieved families is beyond the fiscal affordability may not be accepted. Stop. It is submitted that the fiscal affordability oblique financial constraint cannot be a ground not to fulfill statutory obligation under the DMA 2005 and the constitutional obligation as provided under Article 21 of the Constitution of India. Stop. Para. In the instant case, there is no denial of the fact that the non-practicing allowances is admissible to the petitioners and is being paid. It is only the applicability of revised rates which is under question. Stop. The claim of the petitioner is based on statutory rules and government orders where they have been entitled for the same, and in this regard whatever there is budgetary allocation of resources, then it is presumed that the provision has been made for the same and the plea of financial constraint would not be acceptable. Stop. The state government being and are duty bound to pay the statutory dues of the employees cannot avoid its liability citing financial constraint. Stop para. It is also noticed that whenever a fresh liability is sought to be created on the state, then the contours and parameters of examination are different and usually the stand of the state may be accepted as such except when a claim is made on the ground of discrimination. Stop. Where one class of persons is already receiving the benefit and the same is sought to be extended to the other class, then the ground of financial constraint cannot inhibit a claim on the ground of equal treatment, as the constitutional courts are under a mandate to give effect to the equality clause as mandated by Article of the Constitution of India. Stop para. The respondents have relied upon the judgment in the case of State of Punjab versus Amarnath Goyal 2005 6 SCC 754 in support of their contentions.